The Supreme Court decision in the case of Benjamin TOGADO versus People of the Philippines. Republic Act Number 10591, or the Comprehensive Firearms and Ammunition Regulation Act, recognizes that firearms may be used in the commission of other crimes. Hence, Section 29 of the same law provides for another set of rules on how to determine the imposable penalty in such cases. Section 29 of Republic Act Number 10591 provides as follows. The use of a loose firearm, when inherent in the commission of a crime punishable under the Revised Penal Code or other special laws, shall be considered as an aggravating circumstance, provided that if the crime committed with the use of a loose firearm is penalized by the law with a maximum penalty which is lower than that prescribed in the preceding section for illegal possession of firearm, the penalty for illegal possession of firearm shall be imposed in lieu of the penalty for the crime charged, provided, further, that if the crime committed with the use of a loose firearm is penalized by the law with a maximum penalty which is equal to that imposed under the preceding section for illegal possession of firearms. The penalty of prison mayor in its minimum period shall be imposed in addition to the penalty for the crime punishable under the Revised Penal Code or other special laws of which she is found guilty. If the violation of this act is in furtherance of or incident to or in connection with the crime of rebellion or insurrection or attempted coup d'etat, such violation shall be absorbed as an element of the crime of rebellion or insurrection or attempted coup d'etat. If the crime is committed by the person without using the loose firearm, the violation of this act shall be considered as a distinct and separate offense. In acquitting petitioner, we have discussed that there was reasonable doubt because the prosecution was unable to prove that the firearm presented in court was the exact same firearm confiscated from him. However, we recognize that in previous cases, this court pronounced that the firearm itself need not be presented as evidence, for it may be established by testimony. To avoid any iota of doubt and to protect an accused's constitutional right to be presumed innocent, it is imperative that the exact same firearm recovered from an accused be presented in court. The non-presentation of firearms should be the exception rather than the rule. For clarity on whether the exact same firearm must be presented in court, we lay down the following guidelines. Where an accused is charged with violation of Republic Act Number 10591, the presentation of the exact same firearm is required for the court to determine whether the accused should be convicted, and if so convicted, the proper penalty to be imposed. When a firearm is used in the commission of a crime which prescribes a lesser penalty, Section 29 of Republic Act Number 10591 states that the penalty imposable shall be the penalty prescribed for illegal possession of firearms. In this situation, the use of a firearm is a qualifying circumstance, and the penalty imposable depends on the classification of the firearm. Thus, the presentation of the exact same firearm is also required. The rule remains that qualifying circumstances must be proven with the same quantum of evidence as the crime itself. When the use of a firearm is an aggravating circumstance, or is inherent in or absorbed by the nature of the crime charged, the presentation of the exact same firearm is preferred, but the presentation of secondary evidence may be considered by the courts. In all situations where a firearm is confiscated or recovered from an accused, the confiscated firearm must be marked, photographed, and duly authenticated, and its integrity preserved. The failure to comply with the foregoing requirements should not, however, automatically result in an acquittal, but may constitute reasonable doubt as to the guilt of the accused if not sufficiently justified. For violations of Republic Act Number 10591, courts should not simply disregard the non-presentation of the firearm that was actually confiscated. To say that the presentation of the confiscated firearm is not required may cause the imposition of the wrong penalty, or worse, cause the conviction of an innocent person. The presentation of a certificate stating that the accused is not licensed to own and possess the confiscated firearm is not proof beyond reasonable doubt that would justify conviction for violation of Republic Act number 10591.